Ian Lee and Gina Shin, please unmute and turn your cameras. All right, do you both swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
Thank you. All right, counsel, go ahead.
We're here on a petition to confirm support arrears and to modify support. This is the first setting and neither parent has been personally served. However, we have emailed them each a copy of the petition and are just requesting the court to take judicial notice that they are present and appearing today.
So noted.
And we have an agreement on most of the issues, so I'll read those agreements into the record. The parents agree that the father, Mr. Lee, owes child support arrears of $11,617.59 as of June 30th, 2025, and that he'll pay that balance back at $108 each month beginning August 1st, 2025. Mr. Lee has medical support arrears of $1,391.81 as of June 30th, 2025, and he's agreed to pay that balance back at $57 each month beginning August 1st, 2025. Health insurance for the children is provided through the mother's employer, and it costs $120 each month for the children's coverage. And the parents have agreed that Mr. Lee will pay monthly medical support of $120 each month beginning August 1st, 2025. They're in agreement that Mr. Lee is currently working at Home Depot and he makes $17.50 per hour and he works 40 hours per week. However, the amount of child support proposed by the state was not agreed to. Additionally, the parents agree that there's been no family violence and neither parent is requesting a non-disclosure. So I'll take testimony from the parents. State calls the mother. Ma'am, will you state your name?
Gina Shin,
And what are your children's names?
David Lee, and Evan Lee.
And did you hear those terms I just read out into the record that you and Mr. Lee agreed to?
Yes.
And as to those specific terms, are you still in agreement?
Yes.
Okay. And based on the father's income, we've calculated child support, guideline child support at $622 per month. Do you agree or disagree with that amount?
I can accept the amount that he was proposed.
Okay, and so I think he suggested $500. You said you would be in agreement to that?
That'd be fine with me.
Okay, and is there a reason you think the court should deviate from guideline child support?
Because he needs to support himself too in order to support his kids. So I understand that he needs money for himself too.
Okay. Is there anything else you want the court to know about your case?
No.
I'll pass the witness. The state calls the father, Mr. Lee. Sir, will you state your name?
Yes. Yoon Chong Lee.
And Mr. Lee, did you hear those terms I read out at the beginning of this hearing that you and Ms. Shen agreed to?
Yes.
And as to those specific terms, do you still agree?
Yes.
Okay. And guideline child support is calculated at $622 per month based on your income. Do you agree with that amount or do you disagree?
I agree with that amount. I see the fairness of that, but within my extent, I have to tell the court it is a little bit overextending on my part. When I am able to, yes, of course, I will be able to support and fulfill whatever that I need to do as father of the household, not father of the household for the kids. Yeah.
Were
But
you
500
requesting child support set at $500 each month?
for now, yeah, until I get a better job and could actually drive and yeah.
And do you believe that's in the best interest of your children?
Yes, I believe so.
And how often are the children coming over to your residence and spending time with you?
With me, it's been a while since I was away and getting myself better. So it's been a year since I've seen them. But yes, I'm trying to get to a place where I am a little bit more often.
Okay. And is there anything else you want the court to know about your case?
No.
I'll pass the witness.
All right, the parts y'all agreed to are fine. If Ms. Shin, you're agreed to $500 a month, I don't think that's a good idea, but if that's what you want to do, that's fine. Set child support at $500 by your agreement. All right, the Attorney General's office is going to put that in writing for me to sign as a court order. They'll email you a copy, send out a withholding order to your employer. You're done with court. You can press leave on the Zoom to exit out. Thank you.
Thank you.
Let's see. 39 looks to be ready.
Alobi Osola, Okanfulere, and Olaide Bakari, please unmute and turn on your cameras and counsel. All right. All right, let me swear y'all in. Do y'all both swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Everything I have to say will be the truth and nothing but the truth.
And Mr. Bagley, who do you represent?
I represent Father, Your Honor.
Okay, thank you. All right, Ms. Nutt, go ahead.
Yes, Your Honor. DNA testing was ordered in this case on April 29th, 2025. The child has completed testing. However, we're just waiting for the father to complete testing. So at this point, we're just asking the court to instruct the father to follow through with the testing as ordered and to have the case reset to September 3rd, 2025 at 9 a.m.
Mr. Bagley, do you know why Mr. Okanfulere has not gone to do his testing?
I think there was a little miscommunication, Your Honor, but that is going to be done. Additionally, Your Honor, if you could order the mother to provide citizenship documents for the child so we can confirm the child is actually a U.S. citizen.
Why?
And the child was born in London. Mother is not a U.S. citizen. My client is a U.S. citizen, but does not recall filling out any paperwork whatsoever for the child to actually gain citizenship. And so we're kind of wondering why, because currently the child is in Africa. We don't know. My guy hasn't seen the child in 10, 20 years, something like that. The child's almost 17. So we're just kind of curious over how this occurred.
I mean, I order her to do that. That's not a part of what we're here for. Is the child over 18?
Child will be turning 16 or is 17 now.
Hold on. I have all the documents. Can I show you now? Everything they're requesting, I have it here.
I'm not asking you to do that, but if you want to give it to Mr. Bagley, you can.
Yeah.
You can email him if you like, but I'm not requiring you to do that. You're actually not even supposed to be here on an interstate case. So I'm not sure why you're even here, to be honest. But
Okay.
Miss, what reset date?
September 3rd, 2025. I think worked for Mr. Bagley.
Correct.
September 3rd? Okay. All right, we're reset to September 3rd. Father or alleged father needs to do his testing. This is a second setting for us to get that done. So he needs to do that or else he's going to waive his right to do DNA testing. The Attorney General's office can reach out to you, Mr. Bagley, and tell you where he needs to go. And if he doesn't appear, then I'm going to be forced to do an order and find him to be the father. All right.
Can I say something, Your Honor?
I don't think there's anything to ask at this point except that he needs to do his DNA testing. What is there to ask?
Because he's running, he doesn't want to do it. He's running for responsibility. So I just feel
What
like
did I do?
he's a
What did I
time
just say,
waster.
man?
I love to
I didn't
waste
receive.
time.
What did I just
I
say,
didn't
man?
receive.
I didn't
I
ask
didn't
you
receive
anything,
any.
sir. Sir, I
I've
didn't
not
ask you
received
anything.
anything notification for the
Okay.
DNA test.
Lie. That's a lie. That's a lie.
Bakari, I think I addressed it. If you would listen to me, that he's going to have to do it or else he's going to waive DNA testing. Isn't that what I just said?
Oh, thank you. Thank you, Your Honor.
Did you say that the first time?
No, I didn't hear. I was trying to bring out my documents and my daughter's documents.
Okay, what you need to do is you need to listen to court instead of talking to somebody else or getting papers, okay?
Okay, thank you.
All right, y'all are excused. You can reset to September 3rd. See y'all then. You can press
There you
leave
go.
to exit out. Thank you.
I can leave?
Yes.
Okay, let's see. We have 29 ready for a default.
All right. Marty Miskell and Amber Robinson, please unmute. Or do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. The court notes that Mr. Miskell is not present today. He was present for a prior hearing. He signed the paternity test order. He also did his DNA sample. DNA test results are on file that show that Mr. Miskell cannot be excluded as the biological father. And so we're prepared. We're ripe for default. Go ahead, Ms. Knight.
Yes, Your Honor. The state will call the mother, Miss Robinson. Ma'am, will you state your name?
Amber Robinson,
And what's the name of your child on this case?
Zion Robinson.
And DNA testing shows that Mr. Miskell cannot be excluded as the father's child.
Correct.
And so one thing we're going to do today is establish that Mr. Miskell is your son's biological father. Are you in agreement with that?
Yes, ma'am.
Has there been any family violence in the last 2 years between you and Mr. Miskell?
Yes, ma'am.
When is the last time an incident occurred between you two?
February of last year.
And what happened?
I was choked and I was abused in front of his children with the help of his teenage twins. And he attacked my oldest son as well.
And were the police called out?
Yes, ma'am. Through Box Springs Police. He was charged with 2 felony of choking and family violence and failure to let me call 911.
And is that case still pending or has it concluded?
No, it's still open.
Do you have any current protective orders with Mr. Miskell?
He has a bond condition, no contact with me or my oldest son. It's got about 10 steps in it.
And are you requesting that your address and other contact information be marked as confidential in the order?
Yes, ma'am.
And have there been any other instances of family violence in the last 2 years between you and the father?
No, ma'am.
Are you requesting to be appointed as the sole managing conservator so you can make decisions for the child on your own?
Yes, ma'am.
And do you believe that's in your son's best interest?
Yes, ma'am.
And that's also because Mr. Miskell is not allowed to contact you currently, right?
Correct.
Okay. And are you in agreement to be the parent who can designate your son's primary residence with no geographic restriction, meaning you can live with him anywhere?
Yes, ma'am.
Okay. Are you okay with the father having standard possession schedule with your son?
Yes, ma'am.
And are you requesting that the drop-offs or the exchanges for his visits take place at Miss Piper Elizabeth's daycare in Dallas?
Yes, ma'am.
What kind of health insurance coverage does your child have?
Medicaid.
Do you have any health insurance available through a private source at a reasonable cost?
No, ma'am. I haven't been able to work because I can't afford the daycare.
Do you know if Mr. Miskell is currently employed?
No, he receives VA benefits and child support for his other.
Okay. Do you know if he's capable of holding at least a minimum wage job?
Yes, ma'am, he is.
Okay. And so we used minimum wage to calculate child support. Is it correct that he has 3 other minor children?
Yes, ma'am.
And so we've calculated medical support at $28 per month and child support at $167 per month. Are you in agreement with the medical support amount?
Yes, ma'am.
And are you in agreement or disagreement with the child support amount?
Disagreement because he didn't show up intentionally to provide his VA benefits or his other income intentionally.
And what amount do you think child support should be set at?
I pay $100 weekly just for daycare alone. That doesn't even cover clothes or food. Like I'm just tired of being stagnant. I can't even tell you amount that a 2-year-old needs, and I haven't received anything, not even a cash app, but $1 or put this towards something or nothing like this. Is all intentional.
So you think the child support should be set higher than the 167?
Yes, ma'am.
And are you requesting retroactive child support today?
Yes, ma'am.
And is it correct that you and the father stopped living together after the family violence incident in 2024 February?
Yes, ma'am.
And since then, has he given you any support for your child?
No, ma'am.
So we've calculated retroactive child support since then, and that total amount comes out to $4,676. And are requesting he pay that balance at $100 per month beginning August 1st. Are you in agreement with that?
Yes, ma'am.
Okay. And we're requesting that the court costs from Dallas County be billed to Mr. Miskell. Are you in agreement with that?
Yes, ma'am.
Okay. And let's see. Is there anything else you want the court to know about your case?
No, ma'am.
Okay. I'll pass the witness.
All right, I'm granting the request that you made today, including a finding of family violence, sole managed conservatorship, non-disclosure is granted, no geographic restriction, standard visitation with the exchange location, medical support $28. I could not raise child support. I don't know what his income is. He obviously isn't working, so the only thing he's getting is VA, which I don't know what that is. Could be less than minimum wage. We just don't know. And so I have to base it on what evidence we have, and we don't have any evidence of his income. So it's going to be 167 for child support. Back child support's $4,676, payable at $100 a month. Court cost billed to him. The Attorney General's office will draft an order, put that in writing for me to sign, and email you a copy. And they can try to see what they can do to try to collect that money if there's any source, or VA will cooperate with that. You are done with court, Ms. Robinson. You can press leave on the Zoom to exit out. Thank you.
We have 24 ready.
All right, Stephen Martinez and Lindsay Martinez, please unmute and turn on your cameras. Or do you both swear the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. All right, counsel, go ahead.
We're here on a motion to confirm support, arrears, and to modify support. Upon reviewing this case, the maternal grandmother filed an intervention February 12th, 2025, claiming possession of the child, in a temporary order signed April 8th, 2025. The maternal grandmother was named primary conservator. And so she's also represented by an attorney. Neither the maternal grandmother nor her attorney are present today. I'm not sure if they were aware of this case. So we are requesting that our motion today be referred to district court, and so that all issues can be heard at once. Additionally, this is the first setting. Mr. Martinez and Ms. Martinez have not been personally served, but we have emailed them a copy of the petition, and so we're just asking that the court take notice they're present today.
All right, that seems to make sense. Okay, so I'm first noting that y'all are both here and we're served on the record with the petition. Check your emails if you haven't already. And then if we have other things pending with grandmother, then it probably best to handle it all at one time in the district court. So we'll just kind of leave it out there to see what's going to happen with the custody and all that, and then we can determine what is owed. All right, so I'm going to sign off on a referral to district court. That means I don't know what our next court date will be. That's probably dependent upon grandmother's attorney, since neither one of you have attorneys, and it'll be their responsibility to notify us and the AG of when your next setting is, unless you hire your own counsel. All right, y'all are done with court and are excused. You can press leave on the Zoom to exit out. Thank you.
Thank you.
Thank you.
All right, the next one we have is 27.
Brandon Meadows and Melanie Warren, please unmute and turn on your cameras. Mr. Meadows, I'm waiting on you to turn your camera. Brandon Meadows, waiting on you to turn on your camera. All right, do both of you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Meadows?
Yes.
If you can get a little closer to your camera there, Mr. Meadows, I can barely see your face there. All right, Ms.
Okay.
Duncan.
Yes, Your Honor, we're here in a petition to establish the parent-child relationship. DNA testing was ordered, and the results are showing that Mr. Meadows cannot be excluded as the father of the child. And I'd ask the court to take judicial notice of those results on file from May 27th, 2025.
So noted.
And we have a partial agreement, so I'll go ahead and read the agreements into the record. We are establishing that Mr. Meadows is the biological father of the child Noah, and that Noah's last name will be changed to Meadows. The parents agree that there's been no family violence and there's no request for non-disclosure. They are in agreement that Mr. Meadows have a standard possession schedule and that neither parent has access to private health insurance at a reasonable cost. So Ms. Warren will keep the child on government health insurance coverage. They are not in agreement with conservatorship. However, they do agree that the child's residence will be restricted to Dallas or contiguous counties. Additionally, the medical support and the child support are not agreed to. However, there is an agreement for no retroactive child medical or dental support. So the state calls the mother. Ma'am, will you state your name?
Melanie Warren.
And what's the name of your child?
Noah Moore.
And how old is he?
He's 1.
Okay. And DNA testing came back to show that Mr. Meadows is Noah's biological father, correct?
Yes.
Okay. And did you hear those agreements that I read out into the record?
Yes.
As to those specific terms, do you still agree? As for conservatorship, do you think that you and Mr. Meadows can co-parent and make decisions for your son together?
I mean, we do, but I just agreed to be like the sole conservator because, I have him mostly. I'm the primary caregiver day to day and everything.
Whenever you and Mr. Meadows talk about your son, does it go smoothly or do you get in arguments together?
Lately, it's been smooth.
And has he reached out in the past to be involved in making decisions for your son or not reached out?
Yes, like we've always talked.
Okay, but you're still requesting to be a sole managing conservator?
Yes.
Okay. And is it correct there's been no family violence in the last 2 years between you and Mr. Meadows?
That is true. Well, it has, but I don't want to put it in like the court.
So there has been family violence.
Yes.
When's the last time an incident occurred?
It was like March 2025.
And what happened?
Do I have to say?
Yes, this is we need information so that way we can make a decision on conservatorship.
I was telling him that I was ready for Noah to come back, and he was like, if you want to come get him, then come get him. So I was on my way to come get him, and when I knocked on the door, he came out and he choked me or whatever. I couldn't breathe. And then we started like fighting. And then when I finally was able to, I called 911 and stuff, and they came out. I was able to get my baby, and I went home.
Okay. Did the police arrest him?
No,
Okay. Do you know if there's any criminal charges pending?
no, I dropped them.
Okay. Have there been any other instances of family violence between the two of you?
No,
So do you have any safety concerns for you being around Mr. Meadows at this time?
no,
Okay. And are you okay with your address and your phone number being in the court order?
yes,
And we've calculated calculated medical support for the father to be paid at $288 each month. Ms. Warren, do you agree or disagree with that amount?
I agree.
And we've calculated guideline child support at $513 each month. Do you agree or disagree with that amount?
I agree.
Okay. Is there anything else you want the court to know about your case?
No,
Okay. And is there any protective order or restraining orders right now stating that Mr. Meadows cannot be around you or the child?
I think it was a 90-day one, but I don't know if it's like still active.
I'll pass the witness. The state calls the father Mr. Meadows. Sir, will you state your name?
Brandon Meadows.
And did you hear those agreements I read out at the beginning of this court hearing?
Yes, I heard him.
And as to those specific terms, do you still agree?
Yeah, I agree.
Okay. And do you think that you and Miss Warren can co-parent and make decisions for your son together?
Yes, I agree.
And are you requesting to be a joint managing conservator so you can do that?
Yes,
Do you believe that's in your son's best interest?
yes. If we're both involved in his life, we should both make decisions.
And in the past, have you and Miss Warren been able to communicate together well, or do you have arguments?
No, we don't have any arguments.
Okay. Was there a family violence incident in February or March?
Yeah, it was.
And you heard Miss Warren's testimony. What is it that you choked her when she came over to your residence?
Yeah and no.
What did the police came out, is that right?
Yeah,
And did they arrest you?
no,
And as far as you know, is there any current criminal case pending against you for that incident?
no,
And as far as you know, is there any protective order or restraining orders stating you can't be around Miss Warren or the child?
no. I haven't received any papers or anything about it.
Okay. And you're wanting to be a joint managing conservator, just to confirm, correct?
Correct. Yeah,
Okay. And you are working as a truck driver,
yeah,
and you're self-employed and you make about $3,200 per month, is that right?
correct.
And do you have any other children?
No, not
Okay.
biologically.
Okay. So we've calculated medical support at $288 each month. Do you agree or disagree with that amount?
I agree.
Okay. And we calculated child support at $513 each month. Do you agree or disagree with that amount?
I agree.
Okay. Let's see. Do you have any safety concerns if your address or phone number is printed in this court order?
No, I don't.
Is there anything else you want the court to know about your case?
No, not at the moment.
I'll pass the witness.
All right, I'm going to enter a judgment. Mr. Meadows established legally as a biological father. We're doing name change to Meadows. That means that one of you will need to take a copy of this court order to the birth certificate office and ask for them to change the name. So you'll have to take an additional step to get the name change done. And then once you get a birth certificate, you'll need to go to the Social Security office to change it there as well. Based on the testimony I've heard today, I'm making a finding that there's been family violence in this case. And so I'm ordering that it be sole managed conservatorship because there's been family violence. That tells me that y'all aren't able to reach agreements all the time. Hopefully, things have improved, but choking someone, even just in play fighting, is not normal. That's usually a sign of someone wanting to control the other person. So that's family violence, even if it was just one time. I hear you do not want a non-disclosure of your address, so that's not going to be included. You're going to do standard visitation. Standard visitation usually means that Mr. Meadows is going to come to your residence, Ms. Warren, to pick up the child and bring the child back to your residence. And I guess you're confident that that's okay. We're doing government medical, no back child support. Child support is $513, medical support is $288, and court costs billed to Mr. Meadows. The Attorney General's office will put that all in writing and email you a copy. All payments have to be paid through the child support office. So if you're self-employed, Mr. Meadows, you'll have to send in your payments to the Attorney General's office. It'll all be in the court orders of how you do that, and you can always call them if you have questions, because that's the only way that you're going to get credit for the payments. All right, y'all are done with court. You are excused. You can press leave on the Zoom to exit out. Thank you.
All right, next we have 37.
Jeremiah Mulliken and Leah Narvaez, please unmute and turn on your cameras if you are able.
I'm unable to do my camera.
I know. Do you both swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I do.
Okay. Is this a change? Is this a registration or a change of status or both?
Both, Your Honor. There's a divorce from California. Mr. Mulliken lives here in Texas. Ms. Navarez lives in Arizona.
Okay.
I mean, we do have an agreement on all of the terms. So I can read those agreements out into the record. The parents agree there's been no family violence and no request for a non-disclosure. We're registering the divorce decree from California that was signed August 30th, 2013. The child is now living with Mr. Mulliken. Ms. Navarez is releasing all arrears owed to her from the father. And so the child support arrears judgment after release is $0 as of July 1st, 2025. The parties are in agreement to be appointed as joint managing conservators, with Mr. Mulliken designating the child's primary residence with no geographic restriction. Ms. Navarez will have a standard possession schedule. We calculated mother's child support based on minimum wage, and she does not have any other minor children. Mr. Mulliken has health and dental insurance through his employer. However, he's not receiving any reimbursement from Ms. Navarez, and so her medical and dental support will both be $0 each month. The parties agree that child support will deviate from guidelines and be set at $0 each month beginning August 1st, 2025, because they equally share in expenses for the child. Additionally, Ms. Navarez will pay the court costs that are billed from the county. Those are all of the agreements. I will start by calling the parties. The state calls the father. Sir, will you state your name?
Jeremiah William Mulliken.
And what's the child's name?
Talon Avery Mulliken.
And how old is Talon?
Talon is 15, about to be 16.
And he lives with you?
Yes, ma'am.
And how long has he been living with you?
The majority of his life. He's lived with his mother a couple years when he was younger, and then a couple years at about 10 to 12, and then he's been with me since.
Okay. And you heard those terms I just read out into the record, is that correct?
Yes, ma'am.
And you agree with all of those terms?
Yes, ma'am.
And you believe they're in the best interest of your child?
Yes, ma'am.
And do you want the court to confirm those terms?
Yes, ma'am.
Okay. Is there anything else you want the court to know about your case?
No, ma'am.
I'll pass the witness. The state calls the mother. Ms. Navarez, ma'am, will you state your name?
Leah Narvaez Fitzgerald.
And did you hear all those terms I read into the record?
Yes.
Are you in agreement with all of those terms?
I wasn't sure about the court cost. How much? I didn't know what. Nobody talked to me about that, but yes.
Okay, I'll come back to that. You're in agreement that your son is currently living with Mr. Mulliken, right?
Yes.
Okay. And those other terms I read out, other than the court cost, you're in agreement with?
Yes.
And you believe they're in the best interest of your child?
Yes.
And you want the court to accept those terms?
Yes.
And the court costs are billed from Dallas County. I'm not sure what the costs are, however.
Okay.
I can help pay.
Ms. Navarez, is there anything else you want the court to know about your case?
No.
Okay, I'll pass the witness.
All right, I'll approve the agreement y'all have made. Court costs are assessed to Ms. Narvaez. Dallas County will send you a bill for that. The Attorney General's office will put this all in writing. They'll need time to change to the arrears, so give them a couple weeks at least for that change, and that'll be the order of the court. Y'all are done with court. You can press leave or hang up to leave the courtroom. Thank you.
Thank you.
We have 13 ready for default.
All right. Let's see. Jashawn Jones Gibson and Rajshay Wade, please unmute and turn your cameras. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
The court notes that Mr. Jones Gibson was served February 21st, 2025, and has not filed an answer. Case read for default. Go and proceed.
Yes, Your Honor. The state calls the mother Miss Wade. Ma'am, will you state your name?
Rache Wade.
And what's the name of the child on this case?
Jace Jones.
And how old is Jace?
Jace is 5. He'll be 6 in December.
And when he was born, did the father, Mr. Jashawn Jones Gibson, sign a document admitting that he is the biological father?
Yes.
Okay. Has there been any family violence in the last 2 years between you and the father?
No, not between me and the father, no.
Do you have any safety concerns if your address and phone number are printed in the court order?
No, ma'am.
Okay. Are you in agreement to be appointed as a joint managing conservator so that you and Mr. Jones can make decisions for your child together?
Yes, ma'am.
And are you in agreement to have your son's primary residence be in Dallas County or any contiguous county?
Yes, ma'am.
Okay. Are you okay with Mr. Jones having a standard possession schedule with your child?
Yes, ma'am.
Okay. Let me clarify on the conservatorship. Are you wanting to be a joint managing conservator or a sole managing conservator?
So.
Have you and Mr. Jones been able to make decisions for your child together in the past?
Yes.
And does he reach out to you to try to be involved or not really?
Yes, he's involved.
And what's the reason you're requesting to be a sole managing conservator?
The reason is because I already have primary custody of both of my children, and I'm the one that does the doctor appointments, visits, just everything. So it'll be me.
And do you think being a sole managing conservator is in the best interest of your child?
Yes, ma'am.
Okay. What kind of health insurance coverage does Jace have?
He's under Medicaid.
Do you have any private health insurance available at a reasonable cost?
No, ma'am.
And we've calculated Mr. Jones's income based on information we've received from his employer, which comes to a gross monthly income of $2,591.43. Do you believe it's reasonable to say he earns that much money per month?
Honestly, I really don't know how much he makes and what. I don't know any of that.
Okay, but as far as you know, he is employed?
Yes.
Okay. Does he have any other children? So we've calculated medical support at $233 per month beginning August 1st. Are you in agreement with that amount?
Yes, ma'am.
And we've calculated guideline child support at $404 each month. Are you in agreement with that amount?
Yes, ma'am.
And are you asking for retroactive child support?
I'm sorry,
which
can you
is
explain that?
Child support from the past?
Yes, ma'am, and I believe that's within the past year.
Yes, okay. So you're requesting that the amount be for January 2024 through today?
Yes.
Okay. And based on the current child support calculation we made and then the past wages we've received from his employer, we've calculated a total amount of $8,588, which does also include giving him a credit of $1,500. Are you in agreement with the $8,588 for back child support?
Yes, ma'am.
And we've calculated that Mr. Jones should pay it off at $98 each month. Are you in agreement with that?
Yes, ma'am.
And we're requesting that the court cost from Dallas County be billed to Mr. Jones. Are you in agreement?
Yes, ma'am.
Okay. Is there anything else you want the court to know about your case?
No, ma'am, that's it.
Okay, I'll pass the witness.
Our default judgment granted. We're making a finding of no family violence on the conservatorship. If y'all are cooperating and working well together and there hasn't been any family violence, then it should be joint managing, not sole managing. To kind of keep doing what you're doing. You're going to have primary custody. I don't think you have any custody today. That's what we're under the assumption right now. You have possession, but you don't have custody until we do this order today. So you're going to be joint managing conservators, but you still get the right to decide where the child primarily lives. All the other terms that were proposed or granted, the Attorney General's office will put that in the court order for me to sign, and then they should be able to email you a copy. If they can find an employer for him, they will send out a withholding order to take it out of his check. You're done with court, Ms. Wade. You can press leave on the Zoom to exit out. Thank you.
Okay, thank you.
All right, I think y'all are still working on a couple.
Yes, we do have the 2 double defaults that we could go ahead and do.
Give me a minute. I had to pause with Odyssey to write my notes on this one, so give me just a moment.
Okay.
Okay, I'm ready whenever you are.
The first one we have is
All right, this is Shananovich, Lions God, and Daisha Tucker. So we did a temporary order back in February. We did a temporary order because we weren't sure if he was going to stay incarcerated, establish paternity, and you went in our final default today.
yes, Your Honor. Just making the temporary order final, only addressing the paternity.
Okay, we still believe he's incarcerated.
I can check. I haven't checked on this one. Yes, he's still in custody in Tarrant County Jail.
Okay, all right, temporary order made final.
Okay. And then the other one we have is number 12.
Okay, to Marvian Johnson, Jamie Boren, and Nia Garland. Looks like all three were served. This is a paternity with an additional party, I guess. What's they requesting?
The father, Mr. Johnson, was served in Hunt County Jail. He's still in custody there, and so we're requesting a DNA test on this case, Your Honor, to come back to court on August 27th.
All right, DNA testing granted.
And so I think that's all we have ready for right now.
Okay, all right.
And 26 will be a Spanish case when it's ready.
Okay.
We're ready on number 7.
All right, Jonathan Ingram and Rosalind Martin, please unmute and turn your cameras. Our do both swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. All right, counsel.
We're here on a petition to establish the parent-child relationship. DNA testing was previously ordered and the results are on file, showing that Mr. Ingram is the biological father. So I just asked the court to take judicial notice of those results.
So noted.
And we have an agreement on the issues today, so I'll go ahead and read those into the record. The parties agreed that there's been no family violence in the last 2 years, and neither parent is requesting a non-disclosure. The parties agree that Ms. Martin will be appointed as the sole managing conservator and Mr. Ingram as the possessory conservator, as he lives in Colorado. They are in agreement for Mr. Ingram to have the standard possession schedule for a parent who lives over 100 miles away. Neither parent has access to private health insurance at a reasonable cost, so I believe Ms. Martin will keep the child enrolled in Medicaid. Mr. Ingram's unemployed, and we calculated support for him based on Colorado's minimum wage, which is $14.81 per hour. He has 8 other children that we gave him credit for, and so we've calculated medical support at $29 each month and child support at $288 each month, both starting August 1st, 2025. Ms. Martin is requesting retroactive child support, and we've calculated that amount at $13,824. And let me calculate it a monthly payment. And we'd request that be paid at $120 each month beginning August 1st. Ms. Martin will designate the child's primary residence with no geographic restriction, and we are establishing that Mr. Ingram is the biological father of the child. The state calls the mother. Ma'am, will you state your name?
Rosalind Martin.
And what's the name of the child on this case?
Jasavion Prince Ingram.
And how old is he?
He's 14.
Okay, and DNA testing was done in this case, correct?
Yes, ma'am.
And it shows that Mr. Ingram is the biological father, is that right?
Yes, ma'am.
And so you're in agreement today for the order to show that Mr. Ingram's the biological father and that the parent-child relationship is established?
Yes, ma'am.
And did you hear those other agreements I read into the record?
Yes, ma'am.
Are you in agreement with all of those terms?
Yes, ma'am.
Do you believe they're in the best interest of your son?
No, ma'am, but they told me that he has no say-so in it. His concern is being around his father's family, his brothers, because my son has a stepdad that does for him that Jonathan's family feels as though he shouldn't call him dad. So there's been threats made that they're going to beat my son up, they're going to jump him until he recognizes who his real dad is. And I just don't think that's fair for him to be in another state. And
has Mr. Ingram made those threats himself?
Mr. Ingram has not within the last 2 years, but he has punched my son in his chest based on him calling another man dad, yes. But he has not made those threats in the last 2 years.
That's not true.
We'll get to you in a minute, Mr. Ingram.
Okay, yes, sir.
And Miss Martin, so do you have safety concerns with your son going to Mr. Ingram's residence for
I do.
visitation?
I would, if at all, and I'm not asking for special treatment, but if he can be with his dad, but if he could come here and they go off and do whatever, then that would be more. But I do have safety concerns in the past, and he has done over the last few years. I'm not sure because we haven't had contact, but there's been concerns with child endangerment in the past when his other kids were younger. He was charged with child endangerment. So I want that to be noted. And I do have those concerns. My son has those concerns.
And
that's
how old
not
is your
true.
son again?
He's 14.
Okay. Well, what kind of visitation are you wanting the court to enter then?
Would like for, I won't say that I don't want, I've always wanted them to have a relationship. I was the main person that pushed for them to have a relationship. I traveled back and forth over states. I want him and his dad to have a relationship. It's more so my son, he's afraid. I want them to give them, I want him to be able to have time to make it with his dad and build it with his dad without everyone else being around first. And that safety bond being built back. Because there was a point in time where, yes, I did drop my son off over there and he's taking him from when we were in Colorado to go to Houston. I've trusted that. And up until when he came home with mom, my dad punched me in my chest and he told me not to call my dad. And how do you tell a child, somebody that's been there for them, like he should have the freedom to choose who he wants to call dad. And when that father figure's been there, and that's all it's been. And I feel like my son is just being, I think he's being penalized for wanting a fucking dad.
Miss Martin, other than that visitation we just talked about, are you in agreement with all of the other terms?
Yes, ma'am.
Okay. Do you have any safety concerns with your address or your phone number being printed in the court order?
No.
Okay, I'll pass the witness. The state calls the father. Sir, will you state your name?
Jonathan Eugene Ingram.
And Mr. Ingram, did you hear those terms I read out at the beginning of this hearing?
Yes.
And are you in agreement with those terms?
Yes.
And so you're okay with the standard possession schedule for a parent who lives over 100 miles away, which is 1 weekend per month?
No, I would like a summer, if that was possible. I don't know if that equates to that.
Yes, it also gives you an extended time period with him in the summer.
Okay, yeah, I definitely, yes, for sure. And can I say something?
Have you ever made threats towards your son or towards Miss Martin regarding the stepfather?
Never.
Has your family made any threats?
No, I have not made any threats. My family has not made any threats. Now, kids will be kids. I don't know what my kids said. I didn't check my kids about, because she's previously told me about what they said because they play Fortnite together. So they were just on Fortnite last night together with Xavier. So I don't know what the waterworks is about and everything like that. But then just to put on the record, when she said I got charged with child endangerment, I've never got charged with child endangerment. You can check my record right now. You know what I mean?
Okay.
That seems a little excessive, like a lie. I don't want to call her a liar.
Okay, and so you don't think there's any safety concerns with your son coming to wherever you are for possession?
Absolutely not. I'm a protector, for sure.
Okay. Do you have any safety concerns with your address or phone number being printed in the court order?
No, ma'am.
Okay. Is there anything else you want the court to know about your case?
No.
Okay, I'll pass the witness.
All right, give me just a moment.
Okay.
Okay. The part y'all agreed to, those all sounded pretty reasonable. I don't know why we got off the rails there with everything else. So I think that's what's fair. I'm not asking for your comment.
Yes, sir.
I mean, obviously you don't live in the state, so that sole managing conservatorship makes sense, since it's going to be pretty hard to make decisions if you're not nearby each other. I mean, there's going to be limited visitation just because of distance. So the standard visits 1 weekend a month and summer visitation and holidays it makes sense. There hasn't been any proof that you've given me, Miss Martin, that any of this has happened. We're not talking about a 1-year-old child. We're talking about a teenager. So there's no reason for me to do supervised visits or limit Mr. Ingram to only visiting in Dallas, Fort Worth area. That's kind of unreasonable. He doesn't live here. There's no way that that can happen. So, your child's gonna have to go do his visitation. Um, I mean, I can't dictate to him who he wants to call dad. If he wants to call two people dad, that's up to him. But Otherwise, I expected both of you would make sure that your child is safe. And if there are people that are unsafe around your child, that you would limit their access or make sure that you're supervising any time that they're around. But I mean, it just doesn't make a lot of sense there that we keep Mr. Ingram from visiting with his child. So the terms of the support amounts, those are all fine. We do need to talk about summer visits if we're going to do that this summer or just wait until next summer because the time it was supposed to start had already passed. Supposed to regular summer visits starts June 15th and it's July 2nd. So um I don't know. We were intending to do it this summer or maybe just wait until next summer. I don't know if we made any travel plans or things like that. So um but yeah, I'm not going to do anything different. There's no reason for us to do supervised visits or anything else. If you're asking, trying to allege child endangerment of another child, that's not related to this child. So that's not going to really help anything related to this child. And you haven't presented any documents to show me that anything has actually happened either. So I'm
Well,
not taking that into account. So,
well,
Mr.
Judge,
Ingram, are you able to do summer visitation this summer?
Okay, so boss man, I just moved to Denver. I'm sorry, Your Honor. I just moved to Denver about maybe 2, 3 months ago. So I'm really just getting on my feet right now. So I actually would like to start it next summer for sure.
Okay, that makes sense. I mean,
Yeah,
I know we're just doing this order now and it's trying to all of a rush and then all that. So that's reasonable. It makes sense to me. It's not like you don't want to visit. It's just all of a sudden, all at one time. So very clear. Miss Martin knows that, and the child knows that we're not doing the extended summer visits. The order will read when those start and how you can designate dates. You need to read that when you get a copy of the order so that you can maybe customize it if you want or know when it's supposed to start so you can make plans for next summer. And then the visitation, you need to notify Miss Martin by text or email or something like that, telling her when you intend to have your weekend visitation when you're able to do that. Obviously, it'll be expensive. And so let her know so that way the child's not waiting on you every weekend, wait on you to come. We don't want the child to have um, false expectations when reasonably that's not something that we can just do very often because of the distance. So just let her know when you plan to do it. Please do it. It's very important for your child, especially as a teenager. They need male figures. It
yes,
can't
sir.
hurt to have two of them or more.
Yes,
So,
sir.
so we need to make sure that we're doing it and not just forgetting to do that. All right, the Attorney General's office will draft an order based on what y'all have agreed to do today and what I've ruled today. They will email you a copy of that a few days after today, and y'all are done with court. You can press leave on the Zoom to exit out. Thank you.
Boss,
so
real quick question.
Yes, sir.
So in total, how much is monthly? Because I know you said 120 for the back pay, and then it
You'll need to add it
was
up, sir. It's 288 for child support, $29 for medical, and 120 for back child support payments.
and
okay.
how
So
will
bro,
those payments be made?
I'm sorry,
How will he be making those payments to me?
through the
They
child
told
support
me that
office.
a lot of this was like with
It's
the
all through
proof.
the child support office. It's going
I've
to be
been
in the
told that
court
I was
order.
supposed to give it to you during court. I've asked multiple times how I got the proof or text me everything, and they say the judge will give you an opportunity to give it to him in court, but it keeps getting continued. So how was I supposed to give you proof prior to today?
Well, you should have emailed the court. You could have had it saved on your computer. You could have presented it through your computer.
I
There's a lot of ways you can. The AG's office does not represent you. I don't represent you, so we can't give you legal advice of what you're supposed to present or how you're supposed to present it. So
right, but I've asked multiple times how okay, so how do I show this? The judge's gonna give you a chance in court, but not saying that you
I've
did
already addressed
anything
it, ma'am.
wrong.
I'm not here to argue with you. I've already told you I can't give you legal advice. You didn't present it. You told me it was about another child, not even this child. So that's really irrelevant. It's not
Yes, sir.
relevant to this child.
Okay, yes, sir.
If you had child endangerment with another child, if let's say it was true, then you chose Mr. Ingram to be a father of this child afterwards. So you kind of accepted it. So there's not much I can do now to change it. If you knew that before, then that's a red flag to say, hey, don't have a kid with this guy. I mean, I don't know what else to say on that. I mean, you didn't present me the information. I cannot give you legal advice if you
That's fine.
didn't do it right. So
Yes, sir.
this is what it's going to be. I mean, it's really going to be that Mr. Ingram probably won't visit very often because of the distance. But he's still going to visit some of the time as much as he can, and
Yes, sir.
we need to make sure that happens because it'll help.
Yes,
All
sir.
right. I'm not going to
Thank
argue
you.
with you anymore. Y'all are done with court. You can press
Thank you,
leave
boss.
to exit out. Thank you. Good morning, Ms. Morales. I think we have one case for you.
Good morning.
Yes, it's number 26.
Okay, Thaddeus McDonald and Yara Linis. Solis Rodriguez, please unmute and turn on your cameras.
Sí. Muy bien, esto es McDonald y Solís Yarilenis. Enciendan su cámara.
Buenas tardes.
Good afternoon.
All right, do both of you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Ambos ustedes juran que la declaración que van a dar será la verdad, toda la verdad y nada más que la verdad. ¿Lo juran ante Dios?
Sí.
Yes. Yes.
Mr. McDonald, if you want to testify in English, that's fine, whichever you prefer. But I do ask that you wait for the interpreter to interpret any question that it may be asked before you start answering, okay?
Yes, sir. Señor Tadeus, si usted quiere responder en inglés, lo puede hacer, pero le voy a pedir que primero espere a que siempre la intérprete termine de interpretar la pregunta antes de que usted responda.
Yes, Your Honor, we're here on a motion to modify support.
Estamos aquí presentes para modificar una manutención de menores.
This is our first setting, and neither parent has been personally served. We have emailed them both a copy of the petition.
Esta es la primera audiencia. A ninguno de las partes se les ha presentado la petición de manera personal, pero se les ha mandado por correo electrónico copia de la petición.
And are asking that the court take judicial notice of both their appearances today.
Y pedimos que el juez tome nota de la comparecencia de ambas partes esta mañana.
So noted.
Se anota.
And the parties have an agreement on one issue, the health insurance.
Las partes han llegado a un acuerdo en un asunto que es el seguro de gastos médicos.
Mr. McDonald has private health insurance as a retirement benefit that costs him $600 per month, and he is in agreement to continue to carry that coverage.
El señor McDonald tiene seguro médico privado que le cuesta $600 mensuales y él está de acuerdo en seguir cubriéndolo.
The contested issue is
que está disputado es la manutención del menor.
I'll start by calling the father. Sir, will you state your name?
Voy a llamar primero al padre. Por favor, señor, diga su nombre.
Thaddeus McDonald.
Thaddeus McDonald.
Mr. McDonald, you're ordered this morning to not be in a moving car. So you need a car.
Señor, esta mañana se le ordenó que usted estuviera en un automóvil que no esté en movimiento. Necesita estacionar el carro.
I'm on a Greyhound bus.
Estoy en un camión Greyhound.
Next time you come to court, you're not supposed to be on a moving vehicle.
Yes, sir. I didn't know it would take this long. I thought that I'd be finished by now.
Wait for the interpreter.
Permítale intérprete, señor. Señor, la siguiente vez que usted comparezca al tribunal, no puede estar en un vehículo que esté en movimiento.
All right, Ms. Knight, go ahead.
Continúe, abogada Knott.
Mr. McDonald, what's the name of your child on this case?
Señor McDonald, ¿cuál es el nombre del menor de edad en este caso?
Oscar Cranston McDonald II.
The interpreter is going to ask for repetition. ¿Me lo puedes repetir, señor? Oscar?
Cranston McDonald II.
Oscar Branston McDonald II.
And how old is he?
¿Qué edad tiene él?
5.
5.
And did you hear the agreement I read about the health insurance just a moment ago?
¿Usted escuchó el acuerdo en relación a los gastos, al seguro de gastos médicos que hace un momento leí?
Yes.
Sí.
And are you in agreement to continue to carry health insurance coverage for Oscar?
¿Y usted está de acuerdo en continuar cubriendo el seguro de gastos médicos para Oscar? Yes, sí.
And are you currently retired?
Usted actualmente ya se encuentra jubilado.
You showed that your income for the year was $112,838.
Muy bien, y basado en la declaración de impuestos presentada el 20 del año 2024, en esta declaración de impuestos indica que esos ingresos anuales eran de $112,838.
And so based on that information, the state calculated child support at $1,343 per month.
Basado a esa cantidad, la oficina de la Procuraduría de Texas realizó el cálculo que la manutención del menor tendría que ser de $1,343 mensuales.
Mr. McDonald, do you agree or disagree with that amount?
Señor
I disagree.
McDonald, ¿está usted de acuerdo con esa cantidad o en desacuerdo? En desacuerdo.
I disagree with that amount because a part of that $66,000 was stock that I sold to pay my credit card bills. It doesn't reflect my true income.
Yo estoy en desacuerdo con esa cantidad porque yo tuve que vender mis acciones en una cantidad de $66,000 para poder cubrir el adeudo que yo tenía con mi tarjeta de crédito.
Okay, so you sold stocks last year and that you earned $66,000 from selling those stocks. Is that correct?
Ah,
That's
muy
exactly
bien.
correct. Oh, I'm sorry.
El año pasado usted vendió acciones del mercado y usted entonces tuvo un ingreso de $66,000 por esa venta. Sí, eso es correcto.
And so last year, without the stocks, was your income $46,838?
Entonces, el año pasado, sin contar esas acciones, sus ingresos fueron de una cantidad de $46,838.
Yes, and that's correct. That's reflected on my tax return, which I swore is true. Yes.
Sí, eso es correcto y eso refleja en la declaración de impuestos, sí.
And so are you requesting that child support be based off of you earning $46,838 a year?
Entonces, usted lo que está solicitando que se calcule la manutención del menor en base a esa ganancia de $46,838 anuales.
That is what I made in 2024, but I was fine with what I was paying in 2023. Oh, it was based on $70,000. This year was a little bit less, but it's up to the court to decide that. But yes, I would say that. Or the previous year, I'm fine paying the money for what I paid 2023. But that's my income for 2024, exactly, 46,838.
Los ingresos que yo tuve en el 2024, 46,838. En el 2023, yo tuve un ingreso de 70,000, pero ahora es un poco menos, pero el juez es el que decide.
And you have investment properties that earn you income, is that right?
Y en esas ganancias también ha invertido en propiedades, ¿es así?
Can you repeat your answer?
¿Puede repetir su respuesta?
Can you repeat the question?
You do have income property or investment properties that you earn an income from, right?
Yes.
Usted tiene inversión